My name is Aubrey Adams. I'm the director of Every Brain Matters, which is a community of support and advocacy based on science and lived experience. We are so grateful that you are joining us today because we have a very valuable presentation with clear data about impaired driving. I'm going to introduce Corinne Lamarca. She is director of Jennifer's Messengers, and you can visit her website at jennifersmessengers.org. And I'll let you take it from here, Corinne. Thank you.
Thank you again. I'm Corinne Lamarca, and I'm the director of Jennifer's Messengers. We are sounding the alarm about marijuana impaired driving. This presentation will explain why laws for marijuana THC impaired driving are significantly different from alcohol, and it does matter. Ed will discuss a better way states can track marijuana DUIDs, and have enforceable laws to protect our families on our roads. After Ed's retirement as CEO for a medical device firm, Ed's 33-year-old son, Brian, was killed at the hands of two marijuana-impaired drug drivers. They were also on methamphetamine and heroin. Since then, he has worked with victims, prosecutors, defense attorneys, judges, clinicians, drug recognition experts, law enforcement officers, toxicologists, legislators, state officials, and an international list of researchers and other specialists in his quest to increase knowledge on drugged driving. Ed has shared what he has learned through his website, DUIDVictimsVoices.org, and articles published in scientific journals. In 2017, he wrote a bill that passed the Colorado legislature that requires the state to annually collect and publish information on the causes and judicial consequences of DUI arrests based on laboratory data. It is my pleasure to introduce to you Ed Wood of DUID Victim Voices, leading expert in DUID laws and data and a family advocate. Take it away, Ed.
Thank you, Corinne, and Aubrey, thank you very much for setting this up under the auspices of Every Brain Matters. I'm Ed Wood, founder and president of DUID Victim Voices, DUID standing for Driving Under the Influence of Drugs. As Corinne pointed out, our son Brian, age 33, was killed by two drivers at the wheel of one vehicle, women impaired by marijuana, methamphetamine, and heroin. The judge opined that the crash would not have occurred were it not for drug use, yet the women were not convicted of DUI. So I spent time with all of the specialists that Corinne listed, trying to understand how this could possibly happen. Next slide. Along the way, I found myself becoming an expert in the field of drug-impaired driving, and I've been published widely in peer-reviewed scientific journals. I want to share some of that knowledge with you today. Next slide. Colorado courts convict over 900 drivers each year of driving while impaired by marijuana's tetrahydrocannabinol, or THC. Over 2,000 additional drivers are convicted annually of driving under more than one drug, so-called polydrug impairment. The most common polydrug cocktail is alcohol combined with THC. While those numbers pale in comparison with the 12,000 annual Colorado convictions for drunk driving, we must consider the fact that very few drunk drivers are tested for drugs other than alcohol. So polydrug impairment is undoubtedly a much greater problem than what is currently reported. Alcohol's DUI per se laws certainly make it easier to enforce laws against drunk driving. And due to the success of universal alcohol per se laws, many people, including law enforcement and legislators, ask why we can't have per se laws for marijuana's THC. After all, THC is the second most common reported cause of driving impairment. Well, you're about to learn why THC per se laws are the wrong answer for a very real problem. Simply put, THC laws are scientifically invalid, they don't work, and there are better ways of enforcing drug driving laws than per se limits. Next slide, please. The first question many of you should be asking yourselves is, what is a DUI per se law, and is there a difference between DUI and DUI per se? Well, yes, there is a difference. A drunk driver may be convicted of either DUI or of DUI per se. Although a drunk driver can be convicted of both, that is rarely done because it would have absolutely no impact on sentencing. The terms DUI and DUI per se are defined in state laws, and they vary a little bit from state to state. We're showing here Iowa's laws as an example. I've added the bold titles just for clarity, using the common term DUI rather than Iowa's chosen term, which is OWI. The statements otherwise are directly from the statute. Other states have similar statutes that differentiate DUI from DUI per se. So to be convicted of DUI, a prosecutor must prove that the driver was under the influence. Proof does not require any specific blood alcohol level or drug level. A DUI conviction is the only way to convict drunk drivers who refuse to provide a breath or blood sample for evidentiary testing. On the other hand, to be convicted of DUI per se, a prosecutor must prove that the driver had a blood alcohol content of 0.08 or more while driving. The Latin term per se simply means by itself. There is no need to prove impairment. Having a BAC of 0.08 does not prove that you were drunk, merely that if driving, you are in violation of the state's DUI laws. Next slide, please. 6 states have DUI per se laws for marijuana's THC. 5 nanograms per milliliter for Washington, Montana, and Illinois, and 3 nanograms per milliliter for West Virginia. Ohio and Nevada have per se limits for several drugs, including 2 nanograms per milliliter for THC. Virginia has per se limits for several drugs, but not for THC. Virginia recently considered and rejected imposing a 3 nanogram milliliter THC limit, like its neighbor, West Virginia. 15 other states have zero tolerance laws, 9 of which include THC. All of these per se laws are based on a finding that drivers above the per se limit are simply in violation of state law. The laws are based on a policy decision rather than upon finding that any measurable level or specified concentration of drugs is impairing. Now, many people use the terms driving under the influence of cannabis or marijuana impairment, but regardless of what state laws claim in some of the states, forensic toxicology laboratories do not measure cannabis or marijuana in blood. They can't. Cannabis is a plant, roots, stems, leaves, and all. Marijuana is that portion of the cannabis plant that users smoke. Neither cannabis nor marijuana gets into a driver's bloodstream. Chemicals get into the bloodstream by smoking, vaping, or eating. One of those impairing chemicals is delta-9 tetrahydrocannabinol, also known as THC. And THC is what laboratories measure. And that's why I refer to THC impairment rather than cannabis impairment that you might hear otherwise. Next slide, please. It's important to understand that THC does not impair a driver's blood, and neither does alcohol. Drugs like alcohol and THC impair a driver's brain, not his blood. Police cannot test for drug levels in drivers' brains, so they test the next best thing. They test blood. This works very well for alcohol. It doesn't work at all for THC. THC is unlike alcohol chemically, biologically, and metabolically. So it would be a surprise if what works well for alcohol also works for THC. And in fact, it doesn't. Here's proof. Next slide, please. First, let's compare drug concentration levels in blood over time since dosing, with alcohol on the left graph and THC in the solid red line on the right. Both graphs show drug concentrations in blood over an 8-hour period since starting either drinking or smoking. As shown on the left graph, alcohol is metabolized in a gradual straight line fashion. In contrast, fat-soluble THC is quickly removed from blood by redistribution, not by being metabolized. Redistribution of THC occurs as it is rapidly absorbed from the blood by the brain and other fatty tissues and organs. That happens because fat-soluble THC is not readily soluble in blood. For a driver smoking a joint at the time of arrest or a crash, the blood THC levels might be very high, but it would drop substantially before a blood test could be taken. The maximum THC blood level has been shown to drop an average of 73% within the first 25 minutes after beginning to smoke a joint. Well, it typically takes an hour after a DUI arrest before a blood sample is taken. It takes about 2 hours after a crash resulting in death or a serious bodily injury. Therefore, a toxicology lab result will not necessarily represent what the THC level was at the time of arrest. Even after it can no longer be detected in the blood, THC in the body continues to metabolize, shedding water-soluble inactive metabolite back into the bloodstream. And that's shown in the right-hand graph's dashed red line. It's that inactive metabolite that sloppy reporters refer to when they claim that a trace of marijuana was found in the blood of a driver. The blue line on the graph on the right-hand side shows blood THC levels from consumption of a marijuana edible, and we'll talk more about that later. So knowing a driver's blood alcohol level, we can infer how impaired the driver is. That just cannot be done with THC. Next slide, please. These graphs are from my multi-center European study showing a very high correlation between blood alcohol concentration and crash culpability on the left, and no such correlation between blood THC levels and crash culpability on the right. Both results have been replicated in multiple studies, but usually only for alcohol or drugs, not for both. It's worth noting that among impairing drugs, alcohol, not marijuana, is the outlier. Alcohol is the only drug that has shown a correlation between blood drug levels and levels of impairment. As shown here, a driver can be just as impaired at a low blood THC level as at a high THC level. And this is due in part to the redistribution of THC that we just discussed. The lower level of crashes for THC-positive drivers compared with drunk drivers reflects two realities. First, the fact that many THC-positive drivers in the above study were likely chronic users who were no longer acutely impaired, yet they still had THC in their blood. And secondly, on average, a stoned driver is less dangerous than a drunk driver. One must realize that although the average stoned driver is less dangerous than the average drunk driver, not all drivers are average. In fact, very few are. Stoned drivers on a high dose of THC are more impaired than a driver on a low dose of alcohol, and vice versa. Drivers in Colorado that are so impaired by THC only that they were convicted of DUI had a crash rate about 10 times that of a sober driver. Next slide, please. The fact that many marijuana users who test positive for THC are no longer acutely impaired is a primary concern with THC per se laws raised by NORML. NORML is a national organization to reform marijuana laws. In practice, NORML's concern has not been a well-documented finding in the US, likely because police must prove probable cause that the driver was impaired before even obtaining a blood sample to test for drugs. To do otherwise is a violation of the Fourth Amendment to the US Constitution. So in effect, to convict a driver in the US under a per se law, there must not only be a high toxicology laboratory result, there must also be evidence of impairment. But the public's concern is the flip side of the fact that there is no correlation between blood THC levels and levels of impairment. The flip side is that impaired drivers who test below a drug per se limit are not convicted. Unlike normal's concern, the flip side concern is not theoretical. We'll see that on the next slide, please. This is the case of an 8-year-old girl on her way home from second grade in Boulder, Colorado, killed by a 19-year-old college student. The driver admitted consuming marijuana edibles hours before the crash. Unlike smoked marijuana, marijuana consumed in edibles does not create a high blood THC level. We saw that on the graph 3 slides ago. The 1.5 nanograms per milliliter THC found in the driver's blood is about what one would expect of one or even more impairing doses of marijuana edibles. The arresting officer in this case was a drug recognition expert instructor who believed that the driver was probably impaired by drugs. Following proper procedure, he turned the driver over to another DRE who ran a complete 12-point evaluation. She found that the driver was incapable of safe driving, likely due to THC. In spite of that, and due to Colorado's 5 nanogram per milliliter permissible infants law, the charges for vehicular homicide due to DUI were dropped. Instead, the driver was convicted and sentenced to a mere 60 days for careless driving, resulting in the death of an 8-year-old girl. He was sentenced to an additional 90 days for using a fake ID to purchase his marijuana. Next slide. Oh, one more thing. You should realize that when a driver has been taking multiple drugs simultaneously, the effects of those drugs are additive and may even be synergistic. Data from Colorado show that over 2/3 of the drivers arrested for DUI who are THC positive are also positive for other impairing drugs. For those arrested for DUI, polydrug impairment is far more common than impairment by THC alone. But what that means for us is that even if we could establish a valid drug impairment per se level for drugs, a polydrug driver who tests below each drug's per se limit could still be impaired, but could not be convicted under per se laws. Next slide, please. Now let's take a look at data showing that THC legal limits just don't work as lawmakers expected. Colorado passed a THC 5 nanogram per milliliter permissible infants law in 2013. More about what that means in just a moment. The law was passed to improve conviction rates for DUI caused by THC. Improved conviction rates over what was not really known, since the state had no measures of DUI conviction rates at that time. That changed in 2017 when a law that we wrote was enacted, requiring the state to link court and toxicology data to analyze and publish the causes and judicial consequences of DUI. You're about to see the power of data that, as far as I know, is not yet produced by any other state. Next slide, please. But first, we need to understand a very unusual feature of Colorado's DUI law. Colorado has not one, but 2 different impaired driving violations. The first, DUI, driving under the influence, is defined in statute as substantially incapable of safe driving. The second, DWAI, driving while ability is impaired, is degree. So the person is less able than the person ordinarily would have been. Next slide, please. States use a variety of acronyms such as DWI, DUII, OVI, and others. But more importantly, they also vary widely in their definitions of whatever their DUI acronym happens to be. 34 states define DUI statutorily, as shown here. The remaining states do not define the term in their DUI statute. A dozen states use something like Colorado's DUI term, incapable of safe driving, which is a very high bar for a prosecutor to meet. Nearly 24 other states use a much lower bar, including Colorado's definition of DWAI. Some states, like Vermont and Virginia, statutorily define DUI only for drugged driving, but not for drunk driving. I've included Vermont and Virginia in category 3 in the above chart. Next slide, please. Now let's come back to Colorado's permissible inference law. Colorado has a permissible inference level of 5 nanograms per milliliter of THC in whole blood. This is not a per se level where by law no proof of impairment is needed to convict. With Colorado's permissible inference law, a court may infer a driver to be driving under the influence if the blood THC level is 5 nanograms per milliliter or higher, but only if other evidence supports that conclusion. Therefore, unlike a per se law, it does not nearly guarantee a conviction for someone over the limit, but it still poses a nearly insurmountable hurdle for a prosecutor who charges an impaired driver who tests below the limit, as we shall see in a moment. Next slide, please. When the THC permissible inference law was passed in 2013, the legislature applied it only to DUI, not to DWAI. The legislature was focused on trying to make it easier to convict THC-impaired drivers, knowing that recreational marijuana legalization was going to be started the next year. And they also wanted to try to avoid criminalizing non-impaired drivers who tested above the limit. But by ignoring DWAI, the legislature unwittingly enabled an experiment to compare conviction rates for impaired driving with and without a 5 nanogram per milliliter permissible inference level. The next slide shows the results of that experiment as reported last January from 2019 data analyzed by the Department of Public Safety's Office of Research and Statistics. The top table shows data from drivers who tested positive for THC only. The bottom table shows data from drivers who tested positive for alcohol only. Polydrug impaired drivers are not included in these two tables. Each table is separated into two categories. The top two lines are DUI cases, driving under the influence, defined in statute as incapable of safe driving, followed by DWAI cases, driving while ability is impaired, which is defined in statute as impaired to the slightest degree. Each category shows drivers both above and below the legal limits, either 5 nanograms per milliliter for THC or 0.08 grams per deciliter for alcohol. Next slide. First, look at the top lines in the two tables. The DUI conviction rate for stoned drivers above the limit was only 70% versus 93% for drunk drivers above the limit. It appears then that the permissible inference structure of the law does indeed ensure that there are no convictions of drivers based simply on toxicology results. The next slide will have us look at the THC conviction rates for those testing below the permissible inference level. The rate for stoned drivers below the 5 nanogram level was negligible, only 8%, even though the 93% DWAI conviction rate shows that drivers below 5 nanograms were indeed impaired. The next slide will point out the THC conviction rates for DUI and DWAI. And we see that most charges and convictions were for DWAI, not for DUI. 72% of convictions were for DWAI. This tells us that prosecutors have almost abandoned relying upon the 5 nanogram statute. Next slide. The extremely high THC conviction rates for DWAI, for which the 5 nanogram law was not in effect, 99% and 93%, also show that the permissible inference level was not even needed to achieve a conviction. Next slide. Despite the legal definitions of DUI and DWAI, a DWAI conviction does not necessarily mean that the driver was only modestly impaired. This is because DWAI is more of a plea bargain tool than it is, and I'm going to ask you to back up one slide. There we are. It's more of a plea bargain tool than it is a definition of the level of impairment. A DWAI charge is used by prosecutors to achieve convictions more quickly, and it works because legal sanctions for first-time offenders are lower for DWI than for DUI, and a DWAI conviction does not result in a license suspension. We can see the effect of this most convincingly in the alcohol conviction rate table, and we see that nearly half of all alcohol convictions were for DWAI, not for DUI, including 45% of drivers testing at or above the DUI per se limit of 0.08. Those 45% of drivers would have been convicted of the more serious crime of DUI per se had it not been for plea bargains. Now the next slide. So our conclusions are that Colorado's 5 nanogram per milliliter THC permissible inference law is scientifically invalid. It does not work as intended. It prevents convictions of some impaired drivers. It has been shown to be unnecessary to achieve convictions and has been largely abandoned by prosecutors. And that's why I claim the law just doesn't work. The fact that a 5 nanogram law is shown to be not necessary to achieve convictions, plus the observation that a THC 5 nanogram law is irrelevant in the more numerous polydrug impairment cases, is why I claim that the 5 nanogram law's lack of performance probably really does not matter in Colorado, since that state's law does not apply to DWAI. Next slide, please. Here's what other states should learn from Colorado's experiment. First, using a permissible inference structure seems to be effective in avoiding convictions of non-impaired drivers. Remember, we had only a 70% conviction rate for drivers above the limit compared with 93% for drunk drivers above the limit. Second, drivers below 5 nanograms can be impaired at very high rates, as shown by a 93% DWAI conviction rate for drivers below 5 nanograms. Yet they would likely not be convicted at all if they were covered by a 5 nanogram law, as shown by the mere 8% DUI conviction rate for those drivers. And third, it is likely that the definition of DUI may affect the ability to convict drug drivers. The data are not conclusive here, since DWAI in Colorado is used so frequently for plea bargains rather than to differentiate the degree of impairment. So where do we go from here based upon this information? Next slide, please. First of all, I would suggest that states get their own data. Determine what the state's drug driving problem is and what it is not. What are the comparable conviction rates for alcohol impairment, THC impairment, and polydrug impairment? Second, ensure that definitions of impaired driving do not rely on proving that the driver is incapable of safe driving. That's a very, very high bar. Use a lower impairment definition that most states use. Third, if THC impairment convictions remain unacceptably low after ensuring a proper DUI definition, then states should consider a permissible inference law that finds a driver guilty if any level of an impairing substance other than alcohol is found in blood or oral fluid. Since alcohol's per se limit has proven itself as a successful law enforcement tool for over half a century, it should not be included in a proposed permissible inference law. Do not make the mistake of limiting permissible inference to just THC. It should apply to all drugs other than alcohol, and also avoid setting a limit above 0. Next slide, please. So I hope you now understand why we say that THC per se laws are scientifically invalid, they don't work, and there's a better way. Next slide. You can learn a great deal more about this subject at these two websites, everybrainmatters.org and DUID Victims Voices.org. And final slide, we also invite you to sign up for newsletters from Every Brain Matters. Simply click on this QR code with your smartphone, sign up, and join us in the efforts to save our society. I thank you for your interest in this issue, and I would very much welcome any questions that you may have. And let's see if there are any comments. And I see only 31. Well, that's a pretty good response.
Thank you so much. That was a wonderful presentation. And I just want to say before you get to the questions here, you know, Ed and I are both from Colorado. We were there when they legalized and opened the pot shops back in 2014. Here we are, 2023, and the laws still are not corrected and the data is still not being collected correctly. It's shocking, but it's not shocking. So it just floors me. So I thank Ed for giving us this information and providing us the truth on the science and solutions, how we can move forward. So thank you for that, Ed. Do you see any questions that you would like to answer?
Well, let's see a comment here I would like to respond to. And this is one from Joe Dokes, who noted that roadside testing devices for law enforcement officers are coming online. And he referenced one from Hound Labs that is developing a technology to measure THC in exhaled breath, like an alcohol breathalyzer.
Oh, wow.
That has not been used commercially at this point, and there have been some questions on how useful it is to do that from breath. But we do know that we can do roadside testing using oral fluids, and that is being used routinely in some states. Remember that those devices will tell the officer at the roadside if the person has any presence of a group of impairing substances in their breath or oral fluid. But that is not admissible in a court of law to prove impairment.
Mm.
The same is true, by the way. You need to realize this. The same is true with breathalyzers. When a policeman has you blow into a breathalyzer at the roadside, that can be used as proof that the person has probable cause to get an evidentiary test. But that breathalyzer test result cannot be used in court to prove the driver was impaired or that the driver had alcohol greater than 0.08. That requires an evidentiary test. And the same would be true for either the Hound Labs test or the oral fluids testing. So just a caution to know what we can expect of these new technologies as they come on.
Ed, is Colorado using the oral fluids test? Is this called the mouth swab test?
Colorado did a test on it, and as the state sometimes does, they did a particularly inept job in evaluating it. The person that was leading the test told me after 1 year of doing the test improperly, he said, you know, we found that it's like trying to compare apples with bowling balls. There's just no comparison. It wasn't working. The people that were trying to help the state run the test found that the state was not willing to accept any advice from the experts that had actually done this before. So no, Colorado does not use it. Alabama is probably the most state with the most widespread use of it. And here's another comment from Joe Dokes. So toxic test for multiple drugs. That's the oral fluid testing I was describing. And that is, it is very helpful for officers to know whether they should take special precautions in collecting additional data to prove that the driver was impaired. But it does not prove the driver was impaired. So Joe's exactly correct on that. Can the DUI be pleaded or reduced to DWAI? Yes, it can, and that's why it is used so commonly as a plea bargain tool. And then we test the Draeger 5000, but it's way too slow. The Draeger 5000 is takes about, as I recall, it takes about 10 minutes or so to use. And blood, however, is much slower. And remember that you get the blood sample quite a ways after the arrest or after a crash. But then once you have the blood sample, it will take typically weeks sometimes months, depending upon the laboratory, before you know what the results are. So that the arrest is made long before the result is actually known.
I'm going to take the slides down. I think I can do that. I'm not sure if I can.
And I think that is all of the questions. If I missed one of the questions, please, the rest of them were just other thank you comments and so forth,
Yeah.
which I very much appreciate. And people are giving me some of their contacts, which I would be glad to answer any questions that you may have at a later time off schedule if, after this event, if you like.
I have a few kind of questions for you, Ed.
Sure.
And I just want to thank everybody who's put comments in the chat. We see you guys are making comments about all the work you're doing. Please keep that up. Let us know how we can support you. And if you're looking for certain information, just let us know too, so we can guide you in the right direction.
Mm-hmm.
Thank you for standing up for the safety and health of our communities. Ed, you know, I remember back in 2018 in Colorado when people were in an outrage because we were getting towards the end of the year and we were reaching traffic fatality deaths at 500. We were almost at the 500 mark. And then I saw a report come out just 2 weeks ago that we have surpassed that for 2022. And the number is at 745 people we've lost on the roads in Colorado.
That's right. The other thing that's interesting to note, Aubrey, is that we had at one time in the country around 40 to 45% of all the traffic fatalities were due to drunk driving. And at that time, there wasn't much of a concern about drunk driving. It was sort of like a joke almost. I'll take one more for the road before I go, kind of thing. We then had the slogan that MAD came out with: "Don't let friends drive drunk." That plus safer roadways, safer cars, airbags, seatbelts, a whole bunch of different things, drove the death rate down significantly, and it drove the percentage due to drunk driving down as well, down to around 30%. "Friends don't let friends drive drunk" slogan was then dropped, and we have stopped dropping the percentage due to drunk driving ever since. And the percentage skyrocketed going back up in 2020 as part of the pandemic effect, as far as we can tell. But a lot of that data are still coming in. We have a few more questions that have come in that I'd like to address if I could.
Yeah.
One is, do you agree that THC drops significantly in the blood after about 3 hours? Well, actually, it drops more rapidly than that, Joe. The blood level of THC drops from its maximum point about 73% in the first 25 minutes after beginning to smoke a joint. And after an hour, you've lost about 90% of the maximum THC level. After 3 hours, it may be so low that it cannot even be detected with normal toxicology laboratories, unless the user happens to be a chronic user. In that case, you will be able to detect it after 3 hours and sometimes even after a week. So there are big differences there. The second question came up was that wouldn't it be interesting if a law allowing the removal of a hair strand could be instituted? That has a drawback. People also have wanted to use urine, and some states do use urine very, very inappropriately, I would say. When you're testing THC in urine or blood or hair, you're testing THC and or its metabolites long after it has been metabolized. So it would have no bearing on whether or not that person was impaired at the time you took the sample. No bearing whatsoever. So by testing THC in a hair strand, which can be done chemically, that will tell you that THC has been used at some time in the past, but maybe not necessarily at the time that driver had his hair sample taken. Question on what is Michigan laws for DWAI? Boy, that's a, I can't give you all the laws, but Michigan is one that does not define what its DUI is. It simply says that you're under the influence. So it's one of those 15 states that does that. Can you please tell me where I can find the bill to read? And I presume you're talking about the bill that we wrote for Colorado to have them collect their data. Yes, that was House Bill 17-1315. And so if you look up Colorado House Bill 17-1315, you can find that just by Googling it.
Good questions. And some of those questions were from Chrissy, our new director of PAN, the PAN Action Network, with Sam, Smart Approach to Marijuana. So we are excited you joined us, Chrissy, and being part of this network. Thank you so much.
Good.
Yeah.
A question asked, are you streaming this elsewhere? And Aubrey, you might want to talk a little bit about that, about how this is going to be seen.
Yes. So this is being streamed on multiple social media platforms. Every Brain Matters has Facebook platform, YouTube, and Twitter. And then I use my name too, Aubrey Adams. So I have it on Aubrey Adams Twitter and Facebook. Also, we are recording, so there will be a link on our YouTube channel that can be shareable too. So I won't have it up for a few days, but it will be there. So if you subscribe, if you join everybrainmatters.org, you just go to the website, click the join button at the top. You'll get a notification when you join our YouTube channel too, that when I've uploaded this video.
One comment I'd like to make, someone was asking about a question about Michigan's laws, and there's a concern there because, of course, Michigan has recreational marijuana now. One of the activists in Michigan was so upset when his parents were killed by a marijuana impaired driver that he led the effort to get oral fluid devices being allowed by drug recognition experts in the state of Michigan, and that's been very helpful there. Indiana went one step further, and they started using oral fluid testing devices, but just up in the areas of Indiana that border Michigan, because they were concerned about the Michigan drivers coming into their state impaired.
Wonderful. Okay.
One more question. I've seen a person talking about using vision as a THC impairment test. How accurate is that? Gene, the data are still out, still working on that. We don't have full information on that yet. There are several things we can look at. If you do standardized field sobriety tests for alcohol, the most sensitive test to determine alcohol impairment is something called horizontal gaze nystagmus. I'm not going to describe that, but I will tell you that it doesn't work for THC at all. But there are other eye effects that can be detected that will indicate THC impairment. One is the lack of peripheral vision sensitivity. You can also look at vertical gaze nystagmus. You can look at eyelid fluttering, and you can look at a little bit of a certain type of a redness in the eye that all occur with THC. But the one that's most interesting is one that sees a certain type of a type of color blindness that comes up with people are using THC. That's very, very diagnostic, and that's still being tested. Then the convergence test was the other one. Lack of convergence test is an eye test, and that's one where you bring a finger and bring it closer towards a person's eye, and you should get cross-eyed as the finger gets closer and closer. And most people will do that until eventually both eyes go straight again. Unless you're on THC. Then as they say, one eye goes fishing, the other goes hunting. And it's the weirdest thing. You see where one eye goes straight and the other one looks over here. You say, wow, how can you do that?
Wow.
It only happens to people that are on THC.
Wow, I didn't know that.
So.
There's one more question. Do you see it from Catherine? Hi, Catherine.
Yes, yes. Mention that THC lowers after 25 minutes, but the user is still high and impaired. Yes, that's absolutely true. The impairment will last depending upon how much you've taken and depending upon your use history. For a novice user or somebody that's an occasional user, the total impairment is going to be gone after about 4 hours. That's the acute impairment phase. 4 or 5 hours, something like that. If it's an edible, no, it'll be more like about 10 to 12 hours. But if it's smoked, it'll be about 4 to 5 hours. If you are a chronic user, or you're using every single day, you'll go through the acute impairment phase, and that will typically last about 3 hours. After that time, you're no longer acutely impaired. But unlike the naive user, chronic users never go back to their unimpaired baseline status. They go down to a chronic impairment state that is not as good as an unimpaired driver, but not as bad as somebody that is acutely impaired. We have no data that tell us that somebody who is chronically impaired as being a chronic user, that they are as dangerous as somebody who is acutely impaired. We still don't have the data on that, but we do know that they don't drive as safely. That's been shown in the laboratory.
It's so interesting too. Heidi Swan, who's watching us now. So hi, Heidi, the fabulous Heidi Swan. Her and I have been working on some video for education purposes. And when you consume a THC edible, 100% of the THC that's in that edible is going to go into your system. But if you're smoking marijuana, only about 25% of it goes into the system, and the rest is lost with the side stream smoke. So obviously, if you're doing edibles, the impairment's going to be higher, is what I assume. Is that correct, Ed?
Mm-hmm. That's right.
Okay.
That's right. Yeah, the question was asked, are any of the marijuana rapid tests showing promise? There is some promise coming out of this one device. It's an eye test. A research organization is developing something called IMAD that's out of Boston. That's looking quite interesting. Colorado is now testing a device that was richly designed for use in testing cognitive impairment, specifically for Alzheimer's patients. People have done this similar type of assessments of THC impairment for tests that were richly designed to determine if somebody has been too impaired because of old age. And these cognitive impairment tools are interesting, but they have a very wide output. So what they're really useful for is that once you have a baseline for an individual, you know what that level their responses should be to the test questions, then test them again after THC, and if there's a difference, you can say, a person must be impaired. What they don't do so well is to say, based upon that number, I can now say you're impaired, because within a big population, the output number is very, 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 very broad. So that's one of the dilemmas of using cognitive impairment devices. Colorado is testing one right now. They used $700,000 to fund a test for that purpose. And Gene Cole says he was speaking about the IMAD test. So that's one that I'm looking forward to seeing the results of, but it takes a lot of time. It takes a lot of money to do the testing.
And I noticed Joe Dokes put a lot of great links and made a lot of great comments in the chat too. So check those out, everybody. Thank you, Joe.
And Heidi is saying that edibles have behavioral effects that are 5.7 times stronger than smoked marijuana. Heidi, I'm going to look at that article. I have not seen that before. Thank you for that.
And Ed, too, I was wondering, since the edibles or more THC is impairing, what about the THC-induced psychosis? How does that fit into this equation with your impairment? Because that just adds a whole nother level to this and impaired driving. Yeah.
It does, and I think that raises an interesting point, Aubrey. That I mentioned that it's important to realize that if you have just a little bit if you have a single drink, you're not going to get drunk typically. If you have 4 or 5 chances are you're going to be pretty badly impaired. And if you have a bottle of bourbon, you could die from that. So it is dose dependent. Same thing's true with THC, heroin, methamphetamine, any drug you can imagine. These are all dose dependent. And we have data to prove that THC's effects are indeed dose dependent. That's why I said somebody on a high dose of THC can be more impaired than someone on a low dose of alcohol. And we have the data to prove that. So what you're talking about is a very extreme case of somebody that's taken so much of the THC that they have become psychotic. And certainly they're going to be badly, badly impaired.
Yeah. Yeah. Just 10 milligrams can induce symptoms of psychosis. And, and I think that's really a valid point you make there, Ed, because you could take a drink of alcohol and not become psychotic, but you can vape THC or take an edible and have a psychotic experience. It's happening all the time. So we can't compare. It's two different drugs. That's what I really get from your presentation.
Yeah.
Great presentation.
Good. I very much appreciate the comments and the interaction with this group. This has been fantastic. This is better than I thought.
This is great. This is wonderful. We instead of just doing a private webinar, I'm trying this platform where we're going live. So we're reaching a broader audience and reaching the public a little bit more. So it's turning out well. So, and then we'll be able to share it later too. So thank you, Ed, for having your willingness to do this with me. We really appreciate it.
Oh, I'm sorry. Here's another question I missed. Can I tell what I'm so sorry for the loss of your son. Can you indicate the drug driver was convicted of something? I'm not sure what the question is, but the driver was convicted of vehicular homicide caused by, it's basically careless driving. And in the state of Washington, that's actually a felony. It's not a felony in the state of Colorado, and it varies depending upon the state. Had they been convicted of vehicular homicide due to DUI, then the prison sentence would have been much longer. But they served prison sentences of 3 and 5 years, respectively, for the two different defendants.
We're deeply sorry for your loss, Ed. And we are grateful that you've taken that and brought it into purpose by sharing this information to help other families.
Yep.
So thank you.
Good.
Okay. Well, I think we'll end the presentation now. I don't see any other comments or questions. We want to thank you all for joining us tonight. You will get a link for this. Just join Every Brain Matters. And Ed, wonderful. Thank you very much.
Thank you to all of you.
Okay. Good night, everybody.